What's going on, everyone? It's been a while since I've been on here. Sorry about that, but there wasn't a lot of information that was worth talking about, I guess. So let me get you up to date if you need a refresher course. Me and Mark, our cases, though fundraised together, we actually filed separately to give us a 1-2 punch. So maybe mine gets through, maybe his gets through, maybe neither one of us do, but 2 shots are better than 1. So we filed separately our cases at the New Jersey Supreme Court. And technically we are still there. Our briefs were filed, I believe December 3rd of 2018 to the New Jersey Supreme Court. By the 8th, New Jersey had responded to our brief. It wasn't even a brief what they submitted. They submitted basically a letter, which you can see in the previous video I had. We then submitted our reply brief to them, and that was done a little bit before Christmas 2018. So now we sit on Easter of 2019, and our case is still pending there. They did not issue or deny a review. Our lawyer, who's a great one, he calls every other week to try to find information, and they keep getting he gets the same answer. It's not ready yet, basically. So now we've had a couple different theories on why. So here goes some of that, so hopefully you can follow along with us. So as our cases moved up, even from the very beginning, there was a case called the Rogers case. Now, the Rogers case actually is going on at the exact same time as our case. But they filed right away with federal courts. So as we were going through our stages in state court, they were going through federal court. Going on at the same time, technically I believe our case was actually filed first, on date wise, but they went a different route. They went federal first. They also have NRA backed money, so that helps them. We only have you guys, so that's a big difference. So they eventually made it all the way to the Supreme Court. So as they made it to the United States Supreme Court, we made it to New Jersey Supreme Court. Still going on at the same time. Now, during that same time frame, the New York Rifle and Pistol Club case against New York City also made it to the Supreme Court. Recently, that case was actually granted certiorari by the Supreme Court. So that case is actually going to be argued. And that case main argument was that New York City does not allow their residents to use the federal law 926A, I believe it is, which allows a person to transport their legally owned firearm from the place that they're legally allowed to have it to any other place that they're legally allowed to have it. So if you're going to a gun range and you're allowed to have it at a gun range, or you have a carry permit, say in New Hampshire, and you live in New York City, federal law allows you to transport that to New Hampshire or to a range, as long as you follow, if you don't have a carry permit, as long as you follow the rules. And that rule states they has to be separate from the ammo and locked in your trunk. And if you don't have a trunk, locked in a case. And your magazines can't be loaded or anything. So, I mean, it's, you know, there's a way of doing it, but New York City, not New York State, New York City doesn't allow those residents who have a permit to own a firearm at their premises, their home, doesn't allow them to carry outside of the city, even for a gun competition or even to a second home. So that case was granted cert. Now, their second part of their argument was the bigger argument, in my aspect, is the bigger argument, because it affects everything. It affects other places, other cases, and that is they want the Supreme Court to answer. They want the Supreme Court to answer what is the right scrutiny level of trying to determine a case. Is it intermediate? Is it strict? There's a couple other ones, I believe, that are lower level levels of scrutiny. And right now, all the lower courts seem to use a lower level of scrutiny, and they shouldn't, because there's a constitutional right. When a case comes up that infringes on, it doesn't matter what the right is. If it's a constitutional right, a fundamental right, they should look at it with the most strict scrutiny as possible, but they haven't. And that's the reason why lower courts have kind of been negative toward the Second Amendment, using two-step approaches and everything else, and using a lower level of scrutiny allows them more flexibility to rule in the state's favor. So anyway, back to that. So that was granted cert. Now, the funny part about that, when they granted cert, other cases in lower levels, like in the Ninth Circuit, in the Young case, I have a video about the Young case. It was a great win for the Second Amendment, but that case was then decided that it was going to go en banc. So the ruling was basically stayed at the 3-judge panel at the Ninth Circuit in Hawaii. So even though it was a win, it kind of got put on hold until the case was reheard en banc, which is the full court in the Ninth Circuit. Probably a week before it was due to go to the Ninth Circuit en banc, that's when the New York case was granted cert. When that was granted cert, the Young case was then actually stayed again. So it was stayed pending the outcome of the New York case. So see how they're all tying together. Now when Young's case got put on a stay, the case in the other Ninth Circuit out of California, Charles Nichols' case, his case was then stayed again for the 4th time, because he's waiting for Young. So there's all that trickle-down effect. And now flash forward, New York is so worried about losing. Not necessarily about losing the part that they can travel outside the state. That's not what they're worried about. They're worried about losing the scrutiny part. Because if it was deemed that you need to have strict scrutiny on Second Amendment cases, it's going to blow the doors wide open. It's going to leave so many cases to be overturned, and a lot of wins, actually, Second Amendment wins could come out of it down the line. So now flash forward to Rogers' case. Now, the Rogers case was at the stage of briefing, and briefing for cert. And Rogers and a bunch of other Second Amendment groups submitted an amicus brief on behalf of Rogers. The state had a certain amount of time frame to submit their opposition brief, and they did not do it. They declined to submit a brief. Only two reasons why states don't file opposition brief. One, they believe the case is frivolous, right? Or two, they believe it has no merit and the Supreme Court should not hear it. So there's another side to that, is the Supreme Court of the United States will not issue a right of certiorari, or grant cert in English, to any case without at least asking the state for a brief. So because New Jersey did not submit a brief, it actually sped up the court. It actually sped them up. Instead of waiting so long for them to review a case, it actually sped it up. And the Rogers case was put on distributed for conference. That means all the briefs were going to go to the judges, and they were going to decide if they want to take the case or not. Well, they did that, and they realized New Jersey didn't submit a brief, and the Supremes, they deemed that the Rogers case had merit, right? Had merit to at least demand that New Jersey submit an opposition brief, or a brief on whatever their stance was going to be. And then that gave actually New Jersey an extra 30 days to study cases and actually read all the amicus briefs, so they could come up with their opposition. So basically they did it to buy time. Then they asked the court for an extension. So they already had all the time that Rogers had. And I'll say we, as in Second Amendment people. They had 30 days originally. Then they had additional 30 days after the briefs were filed. Then they could ask for an extension. Well, they got all that original time. Then the state, or the Supreme Court, gave them time to respond after the Supreme Court smacked them around and said, hey, you need to submit a brief. So then they got that time. But yet that wasn't good enough for the state of New Jersey. They actually asked for an extension, which I thought the Supreme Court should have declined. But whatever. They got their extension. Their extension was this past Friday, April 19th, 2019. And they submitted their brief. Total PDF pages is like 31 pages. But, counting the cover and all the table of contents and all that stuff, it's actually really not that long. But their brief was really bad. A lot of stuff in their brief that has already been thrown out by multiple different cases. A range of them. They brought up the what they call that, the Statue of Northampton. That's bogus. You can't use that. It's not even from our country. You can't use that statue. And Heller described it. And other cases from way long time ago said that we can't necessarily use statutes and laws from other countries. They're null and void to us. It's the reason why the founding fathers fled and everybody came here and they fought a war. So we're not like them. Now we can look at their rules and stuff to try to determine where we came up with our Bill of Rights as a reference, but that is it. You can't use the Statue of Northampton to prove that New Jersey's laws are legal. Like, you can't use that as a rule of thumb to say, well, they did it, so this is what it means here. It doesn't work like that. So they also go into the fact trying to say that New Jersey's laws are long-standing, which they're using them terminology because that's what Heller said, that if it's long-standing, then it's legal, right? Or something like that. I don't know word for word. Jay knows it way better than me. But look, don't take this the wrong way, but slavery was long-standing too, right? And a bunch of other shitty-ass laws that affected a lot of people over a long period of time, they were deemed legal and okay. And because it was long-standing, should that mean that it should still be here? No. So that necessarily on its face is a stupid argument. I mean, we do have long-standing laws like the Constitution, right? So if it's long-standing, right, and that should be reason why it should be legal. Second Amendment says, keep and bear arms. And bear means to carry. There doesn't say a home in your home. It doesn't say I need a reason. It doesn't say anything like that. The right of the people to keep and bear arms shall not be infringed. A license is an infringement. Necessarily, I do agree that you probably should. It would help keep people from getting ones that shouldn't. But necessarily, you got 16 states out there that are constitutional carry. So as long as you can buy it legally and pass a background check, you can carry the goddamn thing. But regardless, getting off a little bit. So their brief is saying that it's 95 years old. The law is 95 years old. Now, I didn't do the math. Maybe their math is right. I doubt it. But the first gun control law really in effect in New Jersey was 1924. And all it was need. And back then, need was you had a need. And that need was simple self-defense. So you could go into your chief and say, I want it for self-defense, and that was your need. If you went in and said something stupid like, I want it because I'm going to rob the stagecoach, you know what I mean? That wasn't a need, but from 1924 to 1966, need was okay. And need was okay because it was for a lawful purpose. In the 60s, it changed. And though the Sills, that time frame, he stated that laws people who wanted to get a carry permit would still be the same as it used to be. It's just now you need to go through a different set of steps to get there. That changed some things. But then the 1971 case of Siccardi really, that's really when it got bad. Because now you needed a justifiable need. And what they deemed to be a justifiable need is really what came out of Siccardi. In my opinion. That's where urgent necessity and most of the rules of how to get to justifiable need became what we know today. So at that point, the justifiable need of what it means or how it's determined wasn't even in the code yet. It wasn't even in the law. The 1991 case is the case law itself put the Siccardi rule in the statute. Okay? But it never actually went through all the process that laws need to go through, or policies need to go through, whatever you want to call it. There's a certain way that things need to get into the code. Administrative Procedures Act, so there was a way of doing it, and New Jersey did not do it. They used going through the court, legislatingly through courts and not through legislation. So that was in 91. Now, from 91 all the way to 2017, everybody was getting effed by an illegal code, illegal statute, illegal law. It didn't go through the proper channels. It was in 2018 that justifiable need was recodified and put into law legislatively, the right way, I guess. So officially, justifiable need and all the things that come along with it have only been in law officially since 2018. So it's not fucking long standing. And even if you track it all the way back to 1924, that version, if you had a simple self-defense claim, that was good enough. So they beat themselves up in their own brief. As long as the Supreme Court kind of reads their bullshit as bullshit, it should be a no-brainer. But even further than that, New Jersey says in their brief that even if they were thinking about granting cert, they asked the court to stay granting the cert until the New York Rifle Pistol Club case, right, the one I talked about earlier, until that one is heard. But there's a catch to that. Since the Supreme Court has granted cert in that case, the New York City Police Department and their local authorities have sent a letter to the Supreme Court of the United States asking them to kill the case because they are changing their rules. They basically said, hey, we have been infringing on people's rights to take their firearm outside the city for 6 years. They actually basically admit that they're wrong, and they're going to change their policy to allow these people who have premises permits in New York City to take their firearm outside the city. But even then, it's limited to a range, to a second home, to a competition. That's it. It doesn't say, that I know of, it doesn't say that, hey, if you have a Florida carry permit, that you can take your firearm to Florida. It doesn't necessarily say that. And even if it does, it's still an infringement, because you should be able to go, like the law says, to any place. If you start from a place that you're legally allowed to have it, which is their home, because they have a premises permit, to any other place that they're legally allowed to have a firearm, which is any range, anywhere, right? So they're trying to mute the New York City Rifle Pistol Club's case. So if Rogers' case is put on hold because of the New York case, and then the New York case is mute, then the Rogers case starts up again. It's just a matter of them postponing it and giving themselves more time. That's it. Now, furthermore, they said even if that is mute, there's a case coming up called the Gould case. The Gould case is another carry case. And that has worked its way all the way up through all the levels of court, and now that has been submitted for all the briefs have been submitted, docketed at the Supreme Court of the United States. So that case is actually coming up right after Rogers. Now, the lawyer for that case is my lawyer in my case. So that's great. Now, in the briefs that was filed on Gould, their brief actually asked the Supreme Court to take the Rogers case, stating that if you take the Rogers case and the Rogers case wins, we win. So it would be savings of time. It would save the court time. It would save the court money, in essence. So why argue it twice? Take the Rogers case. If they win, we'll drop it, right? Because it's a moot point at that point. So Gould asked the court to seriously consider granting cert. Well, New Jersey takes that and says, hey, Supreme Court, in their brief, says, because Gould talks about Rogers, how about you review the cases at the same time? So they want to push Gould's case up and hold New Jersey's case back, in probably hopes that they kill both cases, because cases that make it to the Supreme Court doesn't have to take them. So they're kind of trying to force the court's hand. You either accept both of them or you decline both of them. If they're heard at the same time and they kind of have the same points to their case, you can't say one's no-go and the other one is a go when they are reviewed at the same time. But if you separate them, you could decline one and approve the other. So New Jersey's being sneaky. Now that leads back, so now you know where all that stands. What we're going on right now in our case, there was unbeknownst to us, there's actually another case at New Jersey Supreme Court that's a few weeks ahead of me and Mark's. None of us even knew about it. But that case is not really, it's a carry case, but it's not quite the same as ours, because the guy who applied for that carry permit, he asked for a job-based permit, and his job approved it, his chief approved it. It was the judge who denied him, and denied him without even going to the hearing, so he didn't have due process. So that part of the case I get. However, the main part, their main argument, the number one argument, is that he was denied because the judge denied him without due process, but at the same time, in the ruling, said just because he's a security guard, he still has to have justifiable need, which is stupid. That really puts that's like throwing a rock at New Jersey's whole point. They're saying if you have a job based, you can get a permit because it's your job. Now they're saying that even if it is for your job, you have to prove that you have an urgent necessity. If that's what your job requires, that's what your job requires. It's like saying, you're a carpenter, but you're not allowed to have a hammer. It's fucking stupid. So, anyway, that's ahead of ours. It was granted review by the New Jersey Supreme Court. Now, it's happened before where a New Jersey Supreme Court case has actually hurt a New Jersey case that was at the Supreme Court that were going on at the same time. Because this exact happened in Drake. Drake was being reviewed for certiorari at the Supreme Court of the United States, and I always mess up the name, so I'm not going to say the name, but there was another case going on at the New Jersey Supreme Court. The New Jersey Supreme Court granted cert in that case. Because of that cert being granted in that case, the Supreme Court of the United States said, well, we don't need to handle it because New Jersey's going to handle it on their end, so they declined Drake. Well, as soon as the case was officially declined by the Supreme Court, New Jersey decided that they were no longer going to review the case that they just granted review in, thus killing both cases. So that's the big fear going on right now, is that Rogers is up for review, or up for certiorari. The Supreme Court probably in the next month or two are going to decide if they want to hear that case. And you have a New Jersey case that's at the Supreme Court that's ahead of me and Mark's that has already been granted review. Now, Supreme Court should wake up and understand that this happened before, and that's how New Jersey killed both cases. And they see through New Jersey's bullshit and doesn't let it happen again. What should happen, and I hope happens, is the other case's lawyer at the New Jersey Supreme Court asked the Supreme Court of New Jersey for a stay pending the outcome of Rogers. That way, that case doesn't interfere with that case. Now, as for our case, that's still moving forward right now. It could be unofficially stayed within the court's mind. They might not be wanting to grant cert, waiting to find out what happens in Rogers. That is a possibility. If they decide to grant cert anyway, with the same hopes that it kills the Rogers case, we are more inclined to file a motion to stay our case, not withdraw our case, stay our case until the Rogers case is decided. One way or the other. If it's decided good or if it's decided bad, we're going to wait until that case is heard and decided before our case can move forward. Because if Rogers loses, we can move forward with our version of the case, which I think, personally biased probably, but I believe our case is actually better than the Rogers case. That said, me and Mark, along with Jay and David Jensen and a handful of other people, we submitted an amicus brief on behalf of Rogers. Our amicus brief is a slam dunk. It absolutely crushes New Jersey, and it pokes holes in every single argument they have. Our amicus brief, and I read all of the amicus briefs that were filed for, on behalf of Rogers. Our amicus brief is the best one. It actually pokes holes in New Jersey's opposition brief that they just submitted. We actually poked holes in their argument before they even submitted their argument. So let's see what the Supreme Court does. But if they don't grant cert, the case that's ahead of us can move forward fine and dandy. But I think that's a different type of case, because that case is a per applied case, meaning it applies to someone who's getting a job-based permit, and that does not affect all law-abiding citizens who just want their personal protection. That is for job-based applications. He has a big argument about the due process thing, but that doesn't necessarily mean for everybody, because I got my due process. I was just declined. I was just denied. I mean, I went to the hearing. I did that. I was denied. So I don't see that really helping everybody. Me and Mark's case, though, does. And that is the main point right now, is our case helps everybody. Because honestly, if we left it up to the New Jersey to issue on a case-by-case basis, and we had arguments based on our particular situations, New Jersey probably would have gave me my permit. By the time I got to this level, they probably would have just said, here's your permit, kill your case. That's exactly, they've done it before, that on cases that actually people have reasons, they actually have a reason, they eventually give them their permit because they don't want to lose in court. So in an effort to mute the case And it's worth to them, New Jersey, it's worth to them just to give one person their permit. But me and Mark decided to, with Jay, to mold our argument around so it helps everybody. It's not based on my particular incident, you know, or Mark's particular reason. It's not based on that. Now, it's in there, but it's not based on it. We're saying, hey, this person and this person, they actually had reasons and were denied anyway. And that is illegal based on such and such. And we want such and such figured out. That way, if we win, it helps every law-abiding, non-crazy person. Okay? Now, Rogers does the same thing. However, Rogers is trying to get rid of justifiable need as a rule in itself. Me and Mark are not trying to do that. Our thing is, you can keep justifiable need. You just got to sever it from Sicardi. So keep justifiable need, but justifiable need means a lawful purpose. And a lawful purpose is self-defense. It's already been argued and we won. Self-defense is a fundamental right that everybody has, with limitations meaning felons and crazy people. Permanently crazy people. And I say that in a little bit of light because there are people out there that they went through a depression stage in their life. They got divorced, they lost their job, they lost their house or whatever. You know, their kid died of cancer. They went through a stage in their life where they were really down and probably shouldn't have a firearm because of the suicide rate, but it doesn't mean that they're permanently crazy. So let me get that straight. Just because you went through a rough time doesn't necessarily mean that you lose your rights forever. Maybe you lose them temporarily through a due process where you go to court and say, hey, until you get your shit straight, we're going to hold these. We're going to hold your right until you went through some counseling or something, and then you can get your rights back. Maybe that's not a bad idea. But to permanently take somebody's constitutional right away for a moment in time that they were not 100% mentally okay, I don't necessarily think that's a good idea. Because there's plenty of people in this United States that went through a hell of a lot of shit in the previous presidency regarding jobs, and jobs lead to money issues, which leads to divorce, which leads to families being torn apart, which is very bad, and it can be mentally draining on people. So maybe that, I don't mean that when I say crazy. I'm talking about schizophrenic people and stuff that is a permanent issue that they're dealing with, or they have criminally been deemed insane, like that stuff. That's what I'm talking about. I know this is a really long video. I hope everybody followed along with this. If you have any questions, leave a comment. I will try to answer them. I'm not a lawyer. I'm not a historical buff like Jay. But I try to give a personal view, my opinion, which is strongly based on stuff that I've read and learned about over the last 5 years. And I will give you the straight opinion on my feelings, all right, on any situation. It doesn't matter if I might not even be 100% right on the situation, but I want to give you my view on it. I know that the glass, I'll put it this way. I know there's both sides of everything. There's two sides to everything, sometimes even three, okay? And I like to try to look at the glass half full. That's just me. Sometimes I get told I shouldn't put all my eggs in one basket and whatever. I totally agree. I actually agree with that. I shouldn't put all my eggs in one basket. But I do like to try to look at things the glass half full type mentality. Now, living in Jersey, that glass is half full, but the glass has a crack in it. Therefore, it's leaking, okay? So I will try to do my best to answer any questions that you guys have, based on my my experiences and everything else. But look, I want to end it like this. There's a lot of moving parts going on within New Jersey and with other cases around the United States. And I've been really, really working hard to try to tie them together and understand the patterns and try to find out the state's motives, not just here, but other states, like what New York's doing, what Massachusetts is doing. You know, even down in Texas, Texas had a constitutional carry bill that was just killed by a Republican because a Second Amendment advocate did an event protest in the town that that particular congressman lived in. And he thought that it was so over the top that he's like, no, maybe not everybody should get a carry permit or be able to carry without a permit. So he actually killed a bill. So like stuff like that, I try to go around the United States to find out different cases, different laws, because laws sometimes travel. Okay, we all should know that. And what happens in New Jersey does tend to spread to other states that are blue. And then because of people moving out, the area of blue can grow, you know. So Pennsylvania's pretty red, right? But a lot of people are leaving New Jersey and moving to Pennsylvania. So certain areas of Pennsylvania, like Philadelphia, and it's starting to stretch out, it's starting to turn blue. But the majority of the state is red. So I try to link them all together. That way I can understand the process of what's going on and what may come. And to be honest with you, if all these Second Amendment cases that are coming up and going to the Supreme Court within the next year or so, if we don't win them, we could be in very bad shape. And the reason why we would lose them is because of the judges and their viewpoints of the Constitution. Therefore, it's very important, very, very important for the future of the Second Amendment as a whole. It's very important that we get better judges, not necessarily right or left judges, better judges, meaning they look at the Constitution, the whole thing, and understand that that's what our foundation is based off of, and that they're going to honor the Constitution, not their opinion, but they're going to honor the Constitution. And if that's the type of judges that we need to save the Constitution, and the only thing right now that's standing in the left's way, the Democrats' view, to destroy the Second Amendment is Donald Trump. We need to we need to keep him in office for another 4 years when this first term is over. We need to reelect him. You might not like some of the things that he's done or how he talks, but if you like the Constitution and you like the Second Amendment, we need to keep him in office. Okay? So I'm going to end it on that. By the way, this is part 22. Feel free to watch my other videos. But until next time, peace.